Shall we get started? So, we've got girls and Shane today. Two tables. All right. First of all, to start off, how's criminal law, everything else going? Like the progress, everything catching up? Yeah, you're obviously very on top of things, doing practice questions. How about this table over here? So far, so good? Okay, that's good. So as you guys can see, we are currently week 9. Okay, so pretty much 2 more topics, homicide and defenses, and that's pretty much your exams. So that being said, if I don't know what you guys goals are, but if you want to get a HD or something, probably now is a good time to start actually writing some of the past exam questions already. Just like high school, because you guys will be doing some practice questions in the past. Same thing. So exams probably in 1 month's time, isn't it? It's like early June, 1 month and maybe 1 week's time. So maybe once a week you do some practice questions. So far you could already do offenses against the person and sexual offenses. That's enough to make up more than half the marks in your exams. So do get that started. I think there is an assignment coming up for criminal law for you guys as well. So do make sure to complete that in time. Don't leave it to the last minute. I believe it's still quite last minute, but if you have not done it, please go and complete that. All right. So today we're going to look at murder. That's one of the most typical things that we think of in law school. When you come to law school, people will be like, "Oh, are you going to be a criminal lawyer? What's murder? I might get charged with or whatever nonsense." That's what we're going to look at. So we're going to look at the elements of murder, and we're going to do a practice questions following that. Okay, so this probably until today I don't know what your assignment is. I'm not talk about that. But anyway, if your assignment is due like say today or next week or whatever, probably murder wouldn't be inside. But in a sense, this will be obviously part of your final assessment. But also the skills you learn from doing any sort of questions will be directly involved. Okay, so for example, the way you structure how to answer a murder question is exactly the same. Like the structure wise, the content is obviously different, but the structure is obviously the same as how you would do offenses against the person or sexual offenses, for example. Okay, so first of all, what are some of the categories of homicide? Homicide is a broad term to include murder, include things like manslaughter, by dangerous act, by negligent omission. Okay, so the different categories. So first of all, we have murder is traditional sense. Okay, that's the section 3 of the Crimes Act, manslaughter section 5, and then we have a series of statutory homicides, which I'm not going to discuss. Neither I believe none of these are going to be like say really tested in your exam besides murder and manslaughter. So we're really going to focus more on these two over there. Okay. So first of all, just some of these. Again, some of the introductory ideas. So murder, the principles are from common law. Okay, so section 3 basically tells us the maximum penalty for murder is life imprisonment. But really, if you're looking at the elements of the offenses, they're all from common law. So this links us back to the previous 2 weeks. Say, for example, sexual offenses. Is this mainly a statutory offense or common law offense for sexual offenses? Sexual offenses. Do it here. Statutory offenses, very good. What about offenses against the person? Is it a statute or a common law or both? Yeah? Both? Yeah, very good. So this is when you have to sort of distinguish. You need to know where your authority comes from. So if we say offenses against a person, let me write this down. Person, you're looking at common law, you're looking at statute. Okay. If you're looking at sexual offenses, you're pretty much just looking at the statute. Obviously, there are some common law to support the statute, but we're talking about in general where are the laws coming from. Okay, and we're looking at homicide. We're talking about common law. Okay. Obviously, there will be statute to sort of explain what the penalty is, but you could see sort of mainly homicide is still a common law offense. So if when you look at the elements, you want to go ahead and see where the sort of where the crimes, not the crime center, where the common law tells you the elements are. Okay. When I was studying criminal law 2 years ago, criminal law 1, 2 years ago, what happened was I got really confused with this negligent manslaughter thing and the elements. So next week onwards, I'll break that down for you, especially for common law. It's a bit difficult to understand. But anyway, first of all, we start off with this common law definition of murder. For those of you who went to your tutorial workshop this week, I believe you've seen this statement by Sir Edward Cook. Okay, so murder, he defines murder to be, murder is when a man of sound memory and of the age of discretion are lawfully killed, okay, within any country of the realm of any reasonable creature under the king's peace, with malice aforethought, either expressed by the party or implied by law. Okay, blah blah blah, die of the wound or hurt within a year and a day after the same. Okay, a pretty long definition of murder, but you could sort of see certain kind of actus reus and mens rea within this statement. Okay, so that's a very traditional definition of murder. And a lot of these things have become outdated, isn't it? For example, within a day and a year after the same. Like, does it mean that if I kill someone after 2 years, I wouldn't get charged? No, not really today. So then we want to unpack, okay, for your exam purposes, what could you do, right? So, okay, I'm just going to skip this one. Before I tell you about the elements of murder, we're going to look at the statute. Okay, so I'm just going to give you guys, say, maybe 1 minute, 1 to 2 minutes to read through whatever I have here, and then we're going to summarize that a little bit. All right, so what does Section 3 of the Crimes Act mainly tell us? Who wants to summarize for me? Anyone? What does Section 3 tell us? Someone on this table.
All the emergency ones, they'll have the same meaning.
Okay, they tell you they have the same meaning for emergency worker on duty. All right. Is that the main idea of Section 3? Okay, the sentencing protocol for murder. So, maximum sentence is life imprisonment. Standard sentence is 30 years. Okay, if it's emergency worker. Okay, and if not, it's 25 years. Pretty much, it doesn't tell us anything about the elements, isn't it? So therefore, this is probably just like a nice sentence you could say at the end of every murder question, be like what the penalty is. But really, the bulk of the idea still comes from the common law. So, okay, So if you see these elements are still part of the common law, the statute provides some sentencing framework, and we have to rely on case law as our authority. All right, so let's move on. We start with the AR of murder, active series of murder. Okay, so let's see what we have here. Okay, so first of all, the AR for any murder to happen, there must be death of a human being. Okay, someone must die. If no one dies, there's not murder. Okay, it would be quite funny if you get charged with murder and they ask you, where's the victim? Or they tell you the victim is playing video games now. Doesn't make sense. So, first of all, first element of murder, death of human being. Then we have this idea of, there must be death, okay? And then there must be this idea of voluntary conduct. So there must be certain sort of voluntary act. Okay. This reminds me that, yeah, this brings me to one thing. I think I received an email earlier this week or yesterday about the chief examiner sending out a reminder about the LSS notes being blatantly incorrect or something like that. And I think she pointed out one of the idea of positive and voluntary act and the idea of how positive should not be there. Okay, so obviously I want to say that go with what the faculty says. I'm here, my job obviously help you guys get your HDs and say bye-bye to you guys. But the main thing about this is that obviously when I say PVA or when we LSS as a team say PVA, what happens is we just took it down below from like years ago, but I think since the faculty wants that voluntary act, just go with what the faculty says. Doesn't really make too much of a difference to your analysis, but obviously sometimes in the law there's just one or two words that makes a huge difference. So that's just something that I want to point out as well. Yeah, but if there is any discrepancies, please just go with faculty. You can check with me, I'm very open to that, but yeah. So that's with voluntary act, okay? And then there must be human being, okay? If somehow there is a death of a kangaroo when you're driving on your road trip, that's not murder, there must be human being. Fourthly, there must be causation. Okay, this is when you see a whole series of rules. You see that, Shane? A whole series of rules of causation. See, for example, Hamlet, you still need your substantial and operating cause. You have Smith, Paget, Evans, and Gardner, Jordan, right? All these series of cases that tell us, okay, under what circumstances can the chain of causation be broken? Okay. In your exam, I think what I really want you guys to focus on is getting that bulk of the analysis out. Sometimes, you make one or two mistakes, it's not going to cause your HD. For example, if you put a positive and voluntary and instead of voluntary, it's not going to cause your HD to be gone. Okay, but if you tell me in a murder case, you just quote substantial operating costs and then you don't discuss all these sort of nonsense, but all these sort of cases over here, you're not going to get your HD. So do go in depth into discussing all these ideas. All right. So any issues with the actus reus of murder before we go into the details? I need everyone to be on the big picture. Okay. Out of these four elements, which two elements do you think is most contentious? Maybe someone from that table, the two gentlemen over here. Which of the two elements are most contentious that you should spend most in your exam?
Causation.
Yes. Yeah, death of human being and human being probably are pretty straightforward. Okay, so you spend like 2 sentences talk about death, you spend 1 sentence talk about human being, and then you move on to voluntariness and causation. Okay, so first of all, element 1, death of human being. Okay, I just put death of human being together. Okay, I just chunked death and human being together. The main thing in your exam probably just want to refer to section 41 of the Human Tissues Act, where a person has died. Okay, under what circumstances? irreversible cessation of circulation of blood or irreversible cessation of all functions of the brain of the person. In the exam, pretty straightforward. They will just tell you D shot at V, as a result V died. You just assume section 41 applies, but just quote it, briefly mentions 2 sentences, done. All right, no issues with this one. Let's move on. Oh goodness, this is where I'm going to spend like next 10 minutes talking about causation. So first of all, causation has 2 types: factual causation and legal causation. Okay, factual causation would be death had occurred but for these actions. Okay, that's what factual causation is. Legal causation, on the other hand, was this action a substantial operating cause of that's the typo over here, of V's death. Okay, there's a typo over here. Please take note of that. Okay, so legal causation comes from Helen, isn't it? Substantial operating cause. Factual causation, pretty simple, right? But for certain things had done, this result would not have occurred. Okay, so that's but for. There are other ways to determine causation as well, but generally speaking, you just look at these 2. It's more of, sort of a value judgment that you have to make, whether causation is made out, but you still have to use your authority. Whatever conclusion you reach doesn't really matter. But your exam scenario will be quite complicated in a sense. It's not a simple case where the defendant shot the victim and that's it, whether it's murder. Maybe the defendant shot the victim on the leg, okay, but as a result, there was a severe bleeding. Okay, the ambulance came late. There was a flood in Victoria, for example. And then after that, the victim went to the hospital but refused blood transfusion, and then in the end died. You know, so like these are the kind of things that the teachers or myself just generally love to use them a lot. So sort of you can see there is a whole series of chain of causation that sort of have to be broken, or whether it's still substantial operating cause. Okay. Now, this is one of my favorite slides actually when it comes to causation. Usually causation is the one that determines whether the student is HD or not, but yeah, the ideas could be used for your offenses against the person as well, isn't it? So questions surrounding murder or maybe offenses against the person could be quite contentious because of the intervening act, right? Because some of the intervening acts could be the acts of nature. For example, in Helen's case, right, the victim was left near the tide, near the beach, and then there's incoming tide. Okay, was that intervening cause? Answer was no. Act of victim, right? These efforts to escape violence in Royal. What happened in Royal was, I think, was it family violence or something where the Royal wanted to escape, okay, and had no choice but to jump down the building, okay. Or this failure to accept medical advice in blood, that's where the Tin Skull rule is. And then all the act of third party, right? I think it was between husband and wife, not husband and wife, between 2 parties. And then after that, I think the defendant took the victim and used as a human shield, okay, and the police shot at the victim, and as a result, he was claimed there as a defense. Right? That could be act of third party. So these are all very typical sort of exam scenarios that could be made out. And your job, okay, is to discuss all these 3 things. Okay, your job is not there to say whether there is murder or not. In criminal law, there's not much. Criminal law exam, there's not much marks for that. Bulk of the mark goes into really this. Any questions so far? Good. Oh, some of the statements of law. This is also my favorite. Be very careful with this though, because if you do take and paste everything, you might be flagged for plagiarism. But anyway, I'm just going to give you some of these. Okay, I want you to make use of the ideas of causation. So These are some of my favorite things like law exam technique wise. Statements of law is one of the things that's really important. For example, when we have certain kind of things, like say you want to do an exam, you sort of want to have this exam script, isn't it? And in your exam script, you put in these statements of law. And then in the exam, you just vomit these statements of law out, and then you put in the application. Sort of that's the best way to go forward in the 2.5-hour exams. So just now we have all these cases. Obviously, I don't have time to go through 10 different cases if you're in a 1-hour class that I still want to do practice question. So I'm just going to give it to you. In Blau, what happened was those who use violence must take the victim as they find. So what happened in Blau was that Blau, the victim died as a result of the refusal to accept a blood transfusion. And the defendant hoped to use that as novus actus intervenus, but it was rejected. Okay, so for example, in your exam, if you see this idea of blood transfusion, you have to analogize by case to blood, and you have to bring out the thin skull rule. Okay, so that's what happened in blood. Now, in Royale, what happens was the quote, "It seems to me that the principle is best formulated as follows. When the conduct of the accused induces the victim a well-founded apprehension of physical harm, such as to make it a natural consequence that the victim will seek to escape, and the victim is injured in the course of escaping, the injury is caused by the accused conduct." So for example, today, in my pocket, right now, I got a gun, and I point at you, and then you were quite scared. So you ran out of this classroom. And because you were running out of this classroom, there was a staircase, you fell down, and you bleed very seriously. I was charged under section 16 of the Crimes Act for causing serious injury. Can I argue that, oh, it was unreasonable for you to just run away and then that was your own problem? I can't do that, because in Royale's case, okay, I induced a well-founded apprehension of physical harm in you, and because of that, okay, my conduct caused your serious injury. Make sense of the principle? Okay. Now, so what Royal sets out is a reasonable foreseeability test. Okay, there's quite a fair bit of tests. Remember the substantial operating cost test we had it? So now we're looking at one more test of reasonable foreseeability test. Okay, the idea is whether V's death was a reasonably foreseeable consequence of these actions. So this statement of law could be used in your exam as well. Now let's change the scenario a little bit. Okay, let's say for example today I had a gun. Okay, I took out the gun midway in the class. I pointed at Will. I'd be like, "Will, why did you score top the class quiz? I want to shoot at Will." Okay, and before I managed to shoot at Will, for example, before I managed to shoot at Will, there was a police officer. The police officer was just standing right there. He saw the class and he tried to shoot me. As a result, I quickly took Shane as my human shield, and I used Shane. The police officer shot Shane instead. I'd be like, "I didn't shoot Shane, the police officer did." Okay, so am I liable for murder? Then this is when you have to sort of use the case of Paget. Okay, that's precisely what happened in Paget actually. Because the act of the third party, that is the police officer, was not a free, deliberate, and informed decision. So therefore, I would still, okay, it does not relieve me from criminal liability. Okay, so assuming the police officer out of nowhere, he was having his necklace break, whatever, he decided to shoot someone, then obviously that's his problem. But in my case, the example I set out just now, it was sort of an emergency situation. It was not free, deliberate, and informed. Therefore, it will not relieve me from murder. Okay. So you could see that sort of in criminal law, causation is a very huge issue. You need to use all sorts of these kind of tests to help you make a good analysis. All right? Questions so far? No. this could all be used as your headings. All right. Beyond the traditional sense, there is a very special category in your reading guide where it talks about medical cases of incausation. This is especially brought up in the case of Crown and Evans and Gardner and Jordan. Okay, I'm going to just sort of explain to you what is the main issue behind this. Sometimes the medical treatment could contribute to the death of the victim. For example, you call the ambulance took 2 hours to arrive. For example, in Blau's case, the victim refused to accept a blood transfusion, or the victim had a very strange blood type. Or sometimes the doctor had medical negligence. Okay, for example, you needed amputation of your arm. The doctor amputated your heart instead. I don't know how it happened. But anyway, that kind of extreme examples. All right, so this is where we have to see whether it's whether this could be a novus actus intravenous as well. I'm going to give you guys again 1 minute to read through the facts of Crown and Evans and Gardner, and we're going to talk about this rule and the case. All right, so what happened? There was a case of murder, stabbing of the victim or the deceased in the stomach. And then the deceased received medical treatment but died 8 days later as a result of a very common sequel to the operation that he had. The defendant tried to argue that there was a case of medical negligence and therefore has broken the chain of causation. But what happened was it was held that the rule is the medical negligence needs to be so poor that death is accelerated. Okay. So, for example, today, say I shot one of you, and then one of you went to hospital, and you received sort of a very normal treatment, or even a rather below average treatment, for example, and died as a result. Even under that circumstances, I can't just claim the chain of causation has been broken. Okay, let's think of a very extreme example. Suppose one of you, I shot one of you in the arms today, and you needed an amputation, and as a result, maybe the doctor not just amputated you, he cut off all your limbs, cut off everything, I don't know, all sorts of nonsense, and as a result, you died. Okay, he did a lot of unnecessary things. That's when perhaps medical negligence is so poor that death is accelerated. So in Evans, the chain of causation was not broken. Now, in Jordan, however, the medical treatment was had broken the chain of causation because the defendant was not liable because the original wounds healing was quite well advanced and set to heal with negligible risk of death, and further medical treatment was palpably wrong past breaking the chain of causation. Okay, so it'll be quite interesting to go and read exactly what happened in Jordan that sort of led this difference in medical treatment. I can't remember it off my head, unfortunately, but it's something that you guys should study that, and in the exam, they might sort of set a different scenarios. But the main rule of thumb is unless the medical treatment is so poor that accelerated death or is probably wrong, then the chain will not have been broken. All right. Third element, goodness, voluntary act. Not positive and voluntary act. Just bear in mind. Okay, so voluntary act is one that's freely willed. Pretty much the same as whatever we talk about for offenses against the person. I just reuse the slide from there. But anyway, voluntary act. Okay. So that's pretty much the actus reus of murder. Why is the title general law on sexual offenses? Okay, it should be general law on murder. Sorry, guys. So now let's talk about the mens rea. The traditional expression malice aforethought could be understood to be included to be either of the following situations in Victoria today. This still holds today. I'm studying criminal law too, and pretty much that's what I do today, either way. So the elements are pretty much more or less by common law. It doesn't change that easily. Certainly does not change in the past 2 years, I believe. So in relation to murder, the mens rea is you either intend to kill someone or you intend to cause grievous bodily harm that is really serious injury in the Victoria statute's term, or you have a knowledge or belief that death will probably result, or knowledge or belief that death or really serious injury would probably result. So sort of you have this idea of intention and sort of reckless murder, even though that was not a really a term. Okay, if you're reckless in murdering someone, you just charge with murder. So your headings for mens rea will just be these 4 headings. Question? No? Easy. Now, okay. So in relation to intention, the prosecutor must prove that defendant subjectively intended to kill the victim, or cause really serious injury. Okay. Intention is made out if the subjectively intended to cause the specific outcome of their conduct to kill or cause really serious injury. Okay, it's not enough that they merely intended to perform the act that killed V or caused V really serious injury. It's not enough that I just simply pointed a gun and just randomly shot someone. I must have intended to cause death or really serious injury. See that distinction? Okay. Then you just have to use your case law. You just have to use your sort of reasonable argument and make a case out of it. Then we look at the recklessness. Okay. Was it probable that was there a foreseeable probability that death or really serious injury would occur? And then you have to say the recklessness is just comparable and just as blameworthy as intention. Therefore, mens rea for murder can be made out even with recklessness. So for intention wise, there's not too much of a case law. You just have to sort of make an argument. That's pretty much the elements of murder. Any questions? No? All right. We are not talking about imputed intention today, but actually, let me just see. Did I talk about imputed intention? Yeah, I'll talk about this really quickly, actually. That's the last one before I want to talk about the exam question. Okay, imputed intention. This is the idea of constructive murder. Again, in the exam-wise, at least for the past exams, I don't really see this coming up that frequently, so I don't want to confuse you guys. But anyway, it just says that if a person who unintentionally causes death to another person by act of violence, done in the furtherance of crime, okay, will be taken to have sentence level 1 in prison. Sort of as if he had killed that person intentionally. That's what imputed intention is. But you could kind of argue this under recklessness as well, the force out probability. But it just puts this under the statute. In the furtherance of a crime, if there are two crimes, and for some reason or another reason, okay, the person, the act of violence caused death to another person, then it will be taken as murder as well. All right, so that's pretty much it. Let's do a practice question. And that's all for me today after this. So I will give you guys 5 minutes to work through Harry's liability in relation to Sandy's death for 20 marks. I only want you guys to discuss murder. So this question is actually out of 8 marks only for the murder aspect of it. So give you guys 5 minutes and then we'll discuss how you will structure this question. And yeah, I'll hear from you guys in 5 minutes time. Alright, shall we discuss this one? I think some of you are really good. I was walking around and I think some of you realized there was answer key in the next two spots. I just went on to look at the answer key, but anyway, that was a bit of a cheating. So first of all, death of first of all, this is the general structure how you will answer a murder question. Big heading offense, murder. And then talk about actors reus. Element one, death of human being, write the chunk the way that you did it. Was it Dana? Yeah. I still remember, see, not just remember that two guys over there. Yeah, so Dana, the way she did it was very nice. I saw her, she wrote down death of human being, and then she quoted section 41 of human tissue, section 41, 42, 41 of the Human Tissues Act. So, and then you say obviously death occurred, okay, sort of, you just quote the legislation and say death occurred. Voluntary act, again, this is voluntary, it's not contentious on the facts. Take you are done with two elements. Causation is the one that we spent a lot of time discussing. So what are some of the contentious issues that may arise in this question? Maybe someone from the boys.
Level 2 of this, so the ambulance delay and also the
Okay, ambulance delay. Let's write down one by one. Ambulance delay. Refusal of blood transfusion. Anything else? Someone on this table, maybe? What else? You want to continue?
I think also, I don't think it's really contentious, but the fact that she was really skinny and she fell over because of the
Okay. Yeah, so she was really skinny, that's very inclusive in style.
Yeah.
Anything else? The conditional spread as a causation. That sounds like something that will happen in the pub. Like, hey, I didn't hit you. It was him who sort of started all those acts and all sort of nonsense and everything, and then the two people were just fighting. No, that's not okay. So we have that thin person. That's the thin skull rule. You could kind of argue. I heard it during discussion of two of with sort of the act of God, the regional flood in Victoria. Just be very careful, even though it might seem like this one and the ambulance is related, but just because you have a case exactly telling you in Heather's case where there was a tide and this is the flood, I think it could make an effect of that really obvious over here. So do point to that as well. Yeah, so ambulance wise, you kind of want to talk about this. Was it probably wrong that the ambulance came late? Not really, they did accelerate the death, this kind of. And they are also in regional Victoria, so probably, I don't know about Tooraga, but yeah, they might not have ambulance there too closely available. So 1 hour in regional Victoria might seem reasonable or not probably wrong. So this is when you quote the cases of medical treatments, all those medical treatment case law. Refusal of blood transfusion, who do we quote? Blood, thin skull rule. Same thing, okay. Flood, you could quote the case of Hallett. Okay, that's it. And then intention to kill. Was it intention to kill or intention to cause really serious? So probably not intention to kill. You might want to say reckless. Okay, recklessness causing, or you might want to say intention to cause really serious injury, because firing a shot at Sandy's leg would still be quite significant. All right. So this is when how I would just want to talk about how you will be marked in an exam format. This is really important. I don't see a lot of people doing this, but if you understand this concept, you will guarantee you're on a good path to getting HD. In fact, a very high HD in law school. It's not difficult to get 85 out of 100 for exam. like not difficult at all. You just have to practice and you just have to get exam technique. Some people disagree with this table. But anyway, so first of all, if I were marking this question, by the way, I created this everything myself again. If I was marking this question, I would be giving about 4 marks to actors reus. So first of all, discussion that it was a voluntary death of a human being. This probably will get me 1 mark. And then causation, I'll give 3 marks because there's quite a fair bit of ideas to discuss. We start off with whether the conduct was the act of the defendant, Harry's conduct of shooting Sandy's leg, a substantial and operating cause. And then you discuss a series of things, whether Sandy was being very thin, okay? Does that break the chain of causation? Then you link to the thin skull rule and say that no, that does not break the chain of causation. Then you ask yourself whether the medical treatment went probably wrong, in the sense the ambulance took more than 1 hour to arrive, okay? And you say, okay, no, because it's regional Victoria, there was a flood, and you could link the flood to the hazard again, and you say, okay, probably not enough to break the chain of causation. I don't know why I put the work over there, but anything else? The refusal of blood transfusion as well. You want to talk about that, and then once you go through this, you conclude that none of the novice actors interveners have been broken. Then you talk about mens rea. You have to have a very strong, solid understanding of what the mens rea for murder is. So what I would suggest you guys to do first is you want to quote. Okay, you want to quote this. What are the mens rea requirements? Intention to kill, intention to cause very serious injury, knowledge to that death will probably result, or knowledge that grievous bodily harm or really serious injury will result. And then following a logical argument, reasoning, you argue, okay, whether or not it has been made out. Also taking note of the facts. I'll just come to a question a bit. So how I will break down the marks is, I will probably give you 1 mark if you're able to state the law. The 1 to 2 marks to be able to state the law, just stating the law. Then I will give you another 1 mark. Okay, if you're able to explain up to 2 marks. Okay, 1 mark if you state the law, up to 2 marks if you give me the facts. Okay, and analogize whether it falls under intention to kill, intention to cause grievous bodily harm, reckless death, reckless foresight, or grievous bodily harm. And then I'll give you the final mark. You make a conclusion. Doesn't matter which you go, you make a conclusion of which sort of mens rea is being made out. Okay. So that's where you could see the IRAC is being applied. Issue, rule, application, conclusion. And this will be 8 marks. And the remaining 12 marks will go on to the other elements of homicide. Question?
Just in terms of those 4.
Yeah.
That's not something we can like refer to statute.
No.
So it's just like.
It's just what has been accepted in Victoria.
So we don't have like state authority for those 4, which is.
I think this comes from generally, like after all this, they have been accepted in Victoria. Yes. Any other questions? No? Yeah, like what I say, you guys are free to write out an answer to send me for marking. Next week we'll look at the remaining 12 marks. If you want to wait for next week's tutorial, you could do the entire question and send it to me as well. I'm more than happy to take a look. If not, that's all from me today. I'll see you guys next week. Bye bye.